and 1. Government of Cross River State. 2. The Attorney General and Commissioner for Cross River State. Cross River State Judicial Service Commission. My Lord, the parties are absent.
Appearance.
With great respect, my lord. My lord, I am
Yes.
P.O. Aripo.
Yes.
Humbly for the claimant. My lord, our apology for his absence.
Yes. Any other appearance? Have you served the defendants? Registrar? Registrar, have you served the defendants?
Yes, my lord, I'm sure he's aware. We even spoke this morning. Yes. Yesterday I called him to remind him when I was reminded.
Yes,
And this morning.
Okay. It's all right. This matter is for judgment. The judgment is ready. Yes, this is the judgment of the court. The claimant commenced this suit on 29th day of December 2022 by a general form of complaint dated 29th day of December 2022 and filed on the same date, accompanied by a statement of facts, witness statement on oath, list of witnesses, documents to be relied on at the trial, photocopies of documents to be tendered as exhibit. By paragraph 40 of the statement of fact, the claimant claim against the defendant jointly and severally as follows. I'm going to skip reading the reliefs. The reliefs are 9 in number, so I have reproduced them in the body of the judgment. Upon being served with the voting processes commencing this suit, the defendants filed their statement of defense on the 15th day of February 2023, which was by the order of court deeming same properly filed and served. The claimant testified in his case as CW1. CW1, after identifying his witness statement on oath, relied on it and adopted as his evidence in this case. 11 documents were tendered in evidence through CW1. They were admitted in evidence and marked as CWA to CWK. CW1 was cross-examined by counsel for the defendant thereafter he was discharged. The defendant called one Barabase, who testified in defense of the defendant as DW1. No document was tendered in evidence through DW1. At the end of his evidence in chief, DW1 was cross-examined by counsel for the claimant thereafter he was discharged. The case of the claimant, I will skip reading the case of the claimant. It has been reproduced in the body of the judgment. The case of the defendant also, I will skip reading it. The submissions of counsel for the defendant. Counsel for the defendant formulated 3 issues for determinations. I have captured the argument of counsel, but I have captured the argument of counsel in the body of the judgment. So I'm going to skip reading the argument. I go to the submissions of the claimant. The claimant also formulated 3 issues for determination. The argument of counsel for the claimant was captured in the body of the judgment. So I will skip reading the submissions of counsel. I will go straight to the decision of the court now. This is the court decision. I have considered the processes filed in this suit, the evidence laid at the trial, as well as the written and oral submissions of counsel for the parties. From the pleadings and evidence before the court, the claimant instituted this suit to claim his unpaid earned salary for 27 months. He is also seeking for declaration and order that his employment with effect from 3rd of February 2019, magistrate grade 1 on salary grade level 16 subsists and is still valid. He is also contesting the validity of cancellation of his appointment of 3rd of February 2019 by the third defendant. The claimant's appointment of 3rd of February 2019 is as contained in Exhibit CWC, Exhibit CWE, and Exhibit CW1, CWJ, sorry, while the cancellation of the said appointment is evidenced by Exhibit CWA and CWB. The claimant is also asking the court to nullify the contract of employment of 26th day of May 2021, evidenced by Exhibit CWA and CWK, which according to the claimant was accepted under duress. The defendant is asking to the case of the claimant admitted appointment of the claimant as Chief Magistrate grade level 1, on grade level 16, but we are quick to add that the said appointment conducted in January 29, 2019 does not have the blessing of the governor of Cross River State, who must approve all appointment in the state, in consequences of which claimant was not paid his salary for 27 months as claimed. On the new appointment as magistrate grade 2, salary grade level 10, it is the case of the defendant that it was willingly entered into by the claimant, thereby waiving whatever claim he has in respect of the previous appointment. I have thoroughly examined the pleading evidence of the parties, as well as the written and oral submissions of the parties. It is clear to me that the issues that need to be resolved is whether, having regard to the evidence adduced before the court, the claimant has proved entitlement to any of the relief sought. It is well basic principle of law that a claim before the court is circumscribed by the relief claim, and the duty of the claimant is to plead only such facts and material as are necessary to prove the same. He may at the end of the day obtain all the relief claim or less, but he never get more than what he claimed. See Gabriel Atibi versus Cable Metal Nigeria Limited. It is also a basic principle of law that the parties and the court are bound by the case presented by the parties, and so must be confined to the issue properly raised by the parties, and no more. The court is not permitted to stray from the case presented to it by the parties. The court is also not allowed to enlarge or extend the frontiers of the battle fought by the parties before it. See the case of Kuti versus Jibowu. See also Irom versus Okimba, Ogida versus Oliha. For the claimant to succeed in getting the court to grant his relief, he must adduce credible evidence in proof of the case. This is in line with the requirement of the Evidence Act. See section 131, 132, 133 of the Evidence Act. The law is well settled that who desires any court to give judgment in his favor as to legal right or liability dependent on existence of facts which he asserts has to prove those facts exist. The burden of proof in a suit or procedure lies on the person who would defend if no evidence at all is adduced. In this case, it was the claimant who desired this court to grant relief sought before it. Therefore, the burden of proof lies on the claimant, who would fail if he failed to adduce evidence to prove the existence of those facts. He could only secure a favorable judgment if he desired on the strength of his case established by legal evidence and not on the weakness or absence of the defense. Therefore, the legal burden to prove the facts upon which the success of the case depends rested squarely on the claimant. See the case of APC versus Obaseki. Before delving into the main issue calling for resolution, it behoves on me to first and foremost deal with the stance of counsel for the claimant regarding the status of appointment of the claimant by the third defendant at Chief Magistrate 1, grade level 16, in the Cross River State Judiciary with effect from 3rd of February 2019. It is the contention of counsel that the claimant's appointment is a civil service employment with statutory flavor governed by Cross River State Public Service Rules, Cross River State Magistrate Court Law, Cross River State Judicial Service Law, Commission Law, and other relevant statutes. To support this contention, counsel relied on the provisions of Section 6D of the Cross River State Judicial Service Commission Law. Let me say here that the case of KSJSC versus Tolani Supra, Governor of Ekiti State, and another versus Ogunleye, and that of CBN versus Dine, relied on by counsel for the claimant to support his view that claimant appointment is a civil service appointment having statutory flavor are not on all posts with the case at hand. Those cases cannot assist counsel in advancing his view. However, going by the criteria or conditions laid down in the case relied by the counsel, it will be correct to say that the claimant's employment does not have statutory flavor in the real sense of it. This is because there is nothing in the Cross River State Magistrate Court law relied by the claimant to show that the appointment of the claimant is protected by the said statute, or the statute has laid down regulation to govern the procedure for employment, discipline, or discipline of the employee, including termination of employment relationship. This means that the reliance on the cases cannot help the claimants in advancing the position that the claimant's employment has statutory flavor based on civil service appointment. Furthermore, Section 6 of the Magistrate Court Law relied on by counsel only laid down criteria for eligibility for appointment. There is no laid down procedure for discipline, including termination and dismissal from service. For a contract of employment to be said to be laced with statutory flavor, the two vital ingredients, that is, laid down by the Supreme Court must be fulfilled. In the case of PHCN versus Opelo, the Supreme Court stated that those ingredients must coexist for employment to have statutory flavor, i.e., that the employer must be a body set up by the statute. Secondly, the establishing statute must make express provision regulating the employment of the staff and category of employee concerned, especially in matters of discipline. These two ingredients are not all present in the case at hand. What is clear to me is that the claimant's employment is one that is backed up by the Constitution, since the Constitution has provided for the appointment of magistrate by the third defendant, which is a constitutional body established for that purpose. See Section 197, subsection 1C of the 1999 Constitution as amended. See also paragraph 6, subsection C of Part 2 of the third schedule to the Constitution of the Federal Republic of Nigeria 1999 as amended. I am also of the view that Cross River State Public Service Rules 2004 is not applicable to the claimant's employment. This is because the Cross River State Public Service Rules 2004 was made to regulate employment made by the Cross River State Civil Service Commission and not employment made by the third defendant. This also means that the claimant's appointment is not a civil service appointment, as counsel wants the court to believe. It is also pertinent to state that the provisions of the Cross River State Judicial Service Commission Law 1979 is not applicable in this case, as the appropriate and applicable law under which third defendant was established is the Constitution of the Federal Republic of Nigeria 1999 as amended, as it is tried law that applicable law to the course of action is the law applicable as at the time course of action arose. In the case at hand, the course of action arose in 2021. the applicable law in the Constitution of the Federal Republic of Nigeria 1999 as amended. Coming to the substantive case, the claimant in this case is in an attempt to prove his case testified as CW1. After identifying his witness statement on oath, adopted it as his evidence, CW1 also tendered document in evidence. In the course of the trial, they were admitted in evidence and marked as exhibit CWA to CWK. On their part, the defendant, though they filed statement of defense, they failed to call their only witness to appear in court to adopt his witness statement on oath as his evidence in this case. Despite the fact that they have been, despite the fact that they have filed their defense, in his final written address, the claimant counsel has argued that the defendant's failure to call witness to adopt written statement on oath filed on 15th day of February 2023 and give evidence in the matter means the statement of defense is deemed abandoned. In effect, there is nothing to contradict the evidence of the claimant. Counsel asked the court to accept the unchallenged and uncontradicted evidence of the claimant and give judgment in favor of the claimant. In the whole of the defendant's final written address, there was no argument advanced in opposition to the argument of counsel for the claimant on failure of the defendant to call evidence in proof of their pleading. So the pleadings remain mere pleadings and no more. I am inclined to agree with counsel for the claimant on effect of failure of the defendant to give evidence in proof of their case. The net effect of failure by the defendants to call witness to testify in their defense is that the defense which was filed by the defendants will be deemed abandoned. The rationale behind this principle, which is supported by a long line of authorities, is that abatement in pleading which are unsupported by evidence are unavailable to the pleader as they go to no issues and so must be discountenanced. See the case of Odutola versus Farsak, Nigeria Limited. The explanation is very simple. An abatement in a pleading is not evidence in itself and cannot be substituted for evidence. Such abatement does not therefore amount to proof unless it is admitted. See the case of Adake and another versus Akun. See also the case of Ajuwon versus Akani and others. See also Magnusson versus Koiki and others. It is right principle of our law that pleadings are not evidence. Where a party files his pleading but does not give evidence in support of the pleading, as in this case, he is deemed to have abandoned his case. It is to be noted that pleading cannot constitute evidence, and as in the instant case, the pleading of the defendants cannot constitute evidence in proof of their pleading. The witness statement on oath, which will breathe life into the pleading, was frozen and left dormant in the case file, as there was no witness called by the defendant for it to adopt and transform it into evidence in support of the pleading. The defendants who failed to call witness to give evidence in support of their pleadings or in challenge of the evidence of the claimants are deemed to have accepted and rested their case on the fact adduced by the claimant. This is because, as noted earlier in this judgment, abatements in pleadings on which no evidence is adduced are deemed to have been abandoned as mere abatement without proof of facts pleaded does not constitute proof of such fact unless such facts are admitted and there was no such admission See the cases of Wulukem versus Gudi. See also Bashir versus Same and Wegba versus Attorney General of Bendel State. See also Adebitu versus Ogun Folu. Therefore, where a statement of defense is filed and the defendant, as in the instant case, the defendant fails to adduce evidence in support of the arraignment therein, contain that it is tantamount to the abandonment of such pleading, and this court will be right to treat the evidence of the claimant as uncontradicted, more particularly when the witness has not been cross-examined to discredit him or check the credibility of his testimony. See the case of Manarat Global Resource Limited versus Polaris Bank Limited. The failure to call evidence to support the pleading as contained in the statement of defense will clearly lead to presumption that the defendants have no defense to the claim made against them. This is because the burden of proof lies on the party who assert that does not challenge presented. The court may accept the claimant's evidence as uncontroverted. See Ayuk versus and another versus Plateau Publishing Corporation and others. In Beverly Development Analytics Limited versus T Engineering Company Limited, it was held that the defendant may choose to rest his case on the claimant's evidence. That is distinct from failing to call evidence altogether. Resting case is a strategic decision, while failing to call evidence is abandonment of the defense. In the case at hand, the defendant failed to call evidence. This amount to abandonment of their defense and will lead to the court accepting the claimant's case as unchallenged, potentially resulting in a judgment against the defendant. This is because failure to present defense will leave the court with only evidence of the claimant alone. It is pertinent to note that in the case at hand, the defendants have denied the claimant's claim but failed to present evidence in proof of their defense. In civil proceedings, the burden of proof does not rest on one party, but keep shifting among the parties. See Section 131(20)(34) of the Evidence Act and the case of Union Bank versus Rabi Abdul and Co. Limited. The claimant has a duty to discharge the evidential burden on him to present evidence to support the arraignment. See Ekwezo versus Registered Trustees of Savior's Apostolic Church of Nigeria. The apex court part Peter Odili JSC as he then was stated that it need to be reiterated that the burden of proof in civil cases has two distinct facets. The need has two facets. The first is the burden of proof as matter of law, and the pleadings normally termed as the legal burden or the burden of establishing a case. The second is the burden of proof in the sense of adducing evidence, usually described as evidential burden, while the legal burden of proof is always static and never shifting. The other type being evidential burden of proof shift or oscillate constantly as the scale of the evidence preponderates. The failure of the defendant to give evidence to support the statement of defense before the court is an abandonment of his defense. The military governor of Lagos State and others versus Adeyuga and others, the apex court stated that in the absence of evidence to support the statement of defense, the pleading of the defendant's appellants were abandoned Defense is deemed abandoned for all time. See also Okechukwu versus Okafor. Power of Bible, JSC, and Season West. See also First Bank versus Momo. First Bank versus Momo. It is also the law that the effect of the defendant's failure to call evidence in defense of the claim against him at the trial is that he is presumed to have admitted the case against him by the claimant. See Ipeta versus Shell Petroleum Development Nigeria Limited. See also Okoli versus Marinho. However, these do not translate to automatic victory for the claimant. This is because a claimant must succeed on the stance of his case and not on the weakness of the defense. And the absence of statement of defense or evidence laid by the defendant does not exonerate the responsibility on a claimant to prove his claim. See the case of Harka Air Services Limited versus Kezo, and the case of Ogunyede versus Oshunkwea. The benefit derived by the claimant is that in view of the failure of defendant to either file statement of defense or lead evidence, the onus is on the claimant. The onus on the claimant to discharge has now become minimal. That is on minimal evidence, as there is no evidence to put on the other side to tilt the scale. See Adewi versus Oduakwe and Consolidated Resource Limited versus Abofu Ventures Nigeria Limited. See also the case of Bauchi State Government versus Bauchi State Government versus Samaila Ahmed Gumaf. It is in the light of the foregoing position of the law that I shall consider whether the claimant has succeeded in proving entitlement to any of the relief sought. The claimant in this claim is seeking for declaration that his employment of 3rd of February 2019 is still valid and subsistent, and the purported cancellation of the said employment is null and void. He is also claiming payment of 27 months arrears of unpaid salary for work done and not paid by the defendant. There is also claim for shortfall and damage. In law, for an employee to claim payment of salary, he has to prove that he was employed by the employer and he has worked for the period of claim. Once this burden is discharged, the burden will shift on the dependent employer to prove that he has paid the employee for work done and how much he paid the employee. See the case of Ponica Sawmill Nigeria Limited versus Hope. In the case at hand, the employment of the claimant by the defendant as Chief Magistrate Grade 1, Level 16 is not in doubt, as the defendant have not disputed it, as they have no defense before the court. They have abandoned their defense. There is also nowhere they asserted paying the claimant for the services rendered from February 2019 to April 2021. The claimant has bid the CWC, CWE, CWG, CWH, CWI, and CWJ established that he was employed by the defendant as Chief Magistrate Grade 1, Grade Level 16, and worked for the defendant from the date of his employment in February till April 2021 without being paid a balance of 27 months salary. It is right law that claim for arrears of salary being an earned entitlement cannot be affected by dismissal, cancellation, or any determination of employment. The only things that can stand against such a claim is proof. Where there is proof, it will be granted. Where there is no proof, it will be refused. The Supreme Court has made it abundantly clear an employee whose contract of employment has been terminated or dismissed retain the right to claim his earned entitlement. See Uduagam, see Bonham versus Federal Capital Development Authority. See also Underwater Engineering Company Limited versus Dubifon. See also the decision of this court in the case of Casali versus Olegupan versus Access Bank PLC. In view of the foregoing position of the law, I found that when claimant is entitled to his 27 months unpaid salary, unpaid arrears of salaries for services rendered to the defendant on the subsequent appointment of claimant to a lower grade level as per Exhibit CWA and CWB, the defendants, by abandoning their defense, have not tendered any reason for the purported cancellation of claimant's earlier employment as Chief Magistrate Grade 1, Level 6, as evidenced by Exhibit CWC and CWF. It is clear to me the purported cancellation as per Exhibit CWA and CWB clearly against act of misconduct on part of the claimant, and for any action to be taken on misconduct, the claimant deserves to be notified or informed of the act of misconduct against him, which will lead to the cancellation of his appointment. It is not only information, he must be tried for misconduct and found guilty before such drastic action can be meted on him. There is no evidence adduced by the defendants to show that the claimant was ever accused of any misconduct or even tried and found guilty to warrant cancellation of his appointment. The appointment of the claimant being one that has support from the Constitution cannot be wished away at the whims and caprices of the third party or even by the third defendant, except the said appointment cannot be tampered with without following due process. The appointment of the claimant having not been made at the pleasure of the defendant, for any action to be taken, it must be sanctioned by law. Otherwise, it will be in futility. The absence of any reason for cancellation of claimant's appointment goes to support the assumption that the cancellation was not made for any act of misconduct. Rather, it was done capriciously and maliciously. Therefore, the cancellation of the claimants being done not in line with the disciplinary action must be set aside, being an unlawful act and contrary to law. The claimant has also stated that the second contract of employment was executed under duress. In response to the defendants stated that the claimants acceptance of the new appointment offered by the third defendant wherein the earlier appointment of the claimant to Chief Magistrate Court Grade 1, Level 16, was cancelled, shows that the new appointment to Magistrate Grade 2 was not under any coercion, nor was claimant under any compulsion to accept the offer. It is also the case of the defendant that the claimant did not only accept the new appointment, but proceeded to collecting the salary and continue to perform their duties under the new contract. It was also stated that the claimant, by willingly entering into new contract of employment with third defendant in April, has waived her right to be entitled to under the previous appointment. However, all these pleadings have not been backed by evidence. They have been abandoned by the defendant. Therefore, there is nothing that goes contrary to the pleadings of the claimant, as the claimant in his pleading has in his pleading and evidence before the court stated that the acceptance of appointment as per Exhibit CWKCWI, which was lower grade level, to the grade level he was first appointed, was made under duress due to pressure. The claimant has provided the particulars for the duress, which have been as per paragraph 22 and 23 of the statement of fact. In this paragraph of the statement of fact, it is clear to me that the claimant was pressurized to accept the contract of service, which placed him on a lower rank than that which he was which to a lower rank that is not commensurate with his qualification as and experience as a lawyer. Coupled with the non-payment of 27 months salary, the claimant was forced to accept. I agree with the claimant that he was forced to accept the said appointment. Therefore, the said new appointment is null and void in law and cannot stand. From all I have been saying above, the claimant has been able to establish his case on preponderance of evidence as required by law. Therefore, he is entitled to his claim as per his relief as contained in the statement of facts. In the circumstances, the order of the court is as follows. A declaration is hereby granted that the employment of the claimant as Chief Magistrate grade level 1 on salary grade level 16 in the Cross River State Judicial Service Commission with effect from 3rd of February 2019 is still valid and subsisting. A declaration is also hereby granted that the third defendant purported cancellation of claimant's appointment of February as Chief Magistrate grade 1 grade level 16 in Cross River State Judiciary and the purported reappointment of claimant by third defendant of Magistrate grade 2 or grade level 10 in the Cross River State Judiciary with effect from 17th May 2021 is illegal and lawful, void, and of no effect whatsoever, as the said action have no support in law and equity. C. A declaration is hereby granted that the claimant is entitled to salaries and emolument due to Chief Magistrate, due to other magistrates in the Cross River State Judiciary on the same rank and salary grade level, which the claimant was appointed with effect from 3rd of February 2019. The defendants are hereby ordered to pay the claimant the sum of 14 million being unpaid arrears 14,207,530.26 kobo, being unpaid arrears of claimant salary from months of February 2019 to April 2021, and shortfall of salary paid every month to the claimant from May 2021 to March 2022. The defendants to henceforth pay claimant salary as Chief Magistrate 1, grade level 16. The defendants are hereby ordered to reinstate the claimant back to his rank as Chief Magistrate 1, grade level 16, the position to which he was appointed as per Exhibit CWA. The defendants are hereby ordered to pay claimant the sum of 300,000 naira as cost. This judgment is with immediate effect. The judgment is hereby entered accordingly.
As the court pleases. My Lord, we commend the great industry of this court and pray that Allah keep you alive to keep doing justice to litigants that deserve same. Thank you, my Lord.
Yes.
My Lord, the stand-down matter, the lawyer is online now. Barrister Okeja is online.
You say?
Barrister Okeja is online, my Lord. The stand-down matter.
Okay.
Yes, my Lord.
You can
Suit
call
number.
Yes.
Suit number NICM CA 16M 2025 between Mr. Effiong Orok Basi and one, the government of state.
May I throw my order?
Two, the Attorney General of Cross River State and Zenith Bank PLC. My Lord, the judgment creditor is present.
Who is the judgment creditor? Why is the judgment creditor?
Absent, my Lord.
Here is the judgment creditor, my Lord, is present.
His Lordship heard that, sir.
Yes, appearance.
May the court be pleased.
Yes.
I am Austin Okeja. My appearance is for the judgment creditor applicant.
Yes. For the Ghana, she same appearance. Ghana, she same appearance. You have muted yourself. We can't hear you. You have to unmute yourself.
Emma, don't favor himself. Don't mute yourself.
Yes, my Lord.
Okay.
The same appearance, my Lord.
Yes, Mr. Okeja, what is the position?
Yes, my Lord. The Ghanaian affidavit to show cause. It's not an affidavit to show cause. It's rather admitted they have more than enough to pay the judgment debt. We filed a further and a better affidavit on 15th day of April 2025 upon receipt of the Ghanaian affidavit to show cause on the same date. And in that affidavit,
Yes. Yes. It appears counsel is present.
that we used to controvert what they've. The Lord, I'm very sorry. There is an interruption.
Yes. Yes.
Yes, my Lord. We show that they have enough money to pay the judgment sum. They rather brought a judgment, a Ghanaian order that was made in 2023 has long been settled as evidence to show us here, which is not evidence, but rather an admission. So we are praying, my Lord, to make the Ghanaian order absolute. They have enough money to pay us. That's our application, sir.
Yes, Mr. Obi.
Yes, my Lord.
Yes, you heard what counsel said.
Yes, my Lord. I've heard my learned counsel.
Yes.
My Lord, actually, the judgment debtor has an account with us as a judgment creditor has said. But that account is subject to two existing previous Garnish order NIC. And so it will be the bank will not be able to assist the applicant at this stage of the proceeding because there are two already pending Garnish order NIC that is attached to that account. So that is our difficulty, my Lord.
Yes. What is the total amount for the two pending garnishes order NISA? What is the total amount in those order NISA?
My lord, the total amount is about It's about 100 million, my lord.
How much is the account of the judgment debtor? How much is standing to the credit of the judgment debtor?
My lord, the amount that is in the account of the judgment debtor the amount that is in the account of the judgment debtor has not been made
I'm not asking you whether
available to
how much is
to us yet. But
judgment.
The amount that is in the account of the judgment debtor has not been made available to us yet. But the pending Ganishi order NIC has from the information we got from the Ganishi is more than the amount that is in the judgment debtor's account, my lord. The already existing pending.
What I'm asking you is what is the credit balance as at now? What is the credit balance at the time you were served with the order NISA?
My lord, the credit balance, as at the time we were served this order NIC, is
make full disclosure to the
70 million 532,145 naira. That is the amount as at the time we served this garnish order. Meanwhile, the existing garnish order NIC that is attached to this judgment creditor's account is more than that amount, sir, my lord.
When were the two previous order NISA made?
My lord, the first one was made in 2023.
And paid off in 2024.
The second one?
The second one was made in 2024, my lord.
So you are telling me that all those order NISA are still pending. They have not been made absolute and they have not been vacated?
They are not. They are pending in their respective courts, in different courts. As we talk now, as we are talking now, my lord.
It's all right. I'll look at the affidavit.
Very well, my lord.
Yes, the Ghanashi proceeding is hereby adjourned to 7th of May 2023 for
As the court pleases.
As the court pleases, my lord.
Yes, call the next case.
Suit number NICN CA 04-2022 between Bishop Ewana Tiku.
Present, my lord.
Christopher Ntaji and Nkra Marine Limited. My lord, the first claimant on record, Bishop Ewana, is present.
Okay.
Others are absent.
Appearance. Appearance.
The places, my lord, Dr. Paul Ediala. My appearance for the places, my lord. Thank you very much, sir.
Yes, appearance. Any other appearance? Any other appearance? It appears the defendants are not represented. This matter is for judgment. Yes, this is the judgment of the court. On the 19th day of January 2022, the claimants in this suit took out a general form of complaint against the defendant. The complaint was accompanied by a statement of facts, witness statement on oath, list of witnesses, list of documents to be relied on, and photocopies of documents to be relied on. The claim of the claimants against the defendant are as follows. One, an order directing the defendant to compute, calculate, and pay to the first claimant the sum of 44,720,000, being his outstanding salary arrears for 86 months. Two, an order directing the defendant to compute, calculate, and pay to the second claim the sum of 21,375,000, being his outstanding salaries for 75 months and allowances for 7 years. Three, an order directing the defendant to pay to the first claimant his monthly salaries and all his entitlements. In line with the terms and conditions of service from January 2022 until he is properly disengaged from the defendant's company. Four, award of general damages against the defendant to the tune of 100 million naira, jointly and severally for breach of terms of their contracts of service with the defendant. Five, award of special damages of 5 million naira in favor of the claimants being cost of litigation. Upon being served with the originating process commencing this suit, the defendant on the 4th day of December 2023 filed its statement of defense, and the claimant on the 18th day of December 2023 filed a reply. The claimants testified as CW1 and CW2 respectively in proof of their respective cases, while the defendant Paul 1 James Tobomewo, who testified as DW1, in the defense of the defendant. 3 documents were tendered in evidence through this witness in the course of cross-examination. The 3 documents were marked as Exhibit DWA to DWC. The case of the claimant. The claimants were employed by the defendant at different times and assigned different work schedules with condition of service clearly stipulated in their employment letters. The first claimant was assigned the function of executive director administration, while monthly salary on the monthly salary of 520,000 naira, while the second claimant was assigned the role of chief accountant with monthly salary of 250,000. See Exhibit A and B. The claimants were also given job description and additional job description respectively, spelling out their area of attention and designation. According to the claimants, upon their employment in 2006 or 2008 and 2009 respectively, they were paid their monthly salaries through their accounts with Polaris Bank Limited up to October 2014. However, the defendant suddenly stopped paying the claimants their monthly salaries from November 2014 to date. When the situation of the non-payment of the claimant's salaries persisted, the first claimant tendered his resignation on the 8th of February 2018. Upon receipt of first claimant letter of resignation, the defendant, through its managing director, by the letter dated 4th of April 2018, wrote to the claimant putting on hold the letter of resignation, pending when the management of the defendant will meet on the subject matter. According to first claimant, no management decision on them was taken and or communicated to him till date. The second claimant, on his part, tendered his letter of resignation of appointment on the 5th of January 2021. See Exhibit K. The case of the defendant. In his defense, the defendant denied that the defendant held employment in his establishment on position and job specification claim, and that there is no valid contract of employment pleaded before the court to enable the court to determine the rights of the parties. As the appointment letters tendered by the claimants cannot qualify as valid letters of appointment, they are incomplete, disjointed, and not signed by the appropriate person responsible for approving employment at the defendant's office. They are not admissible in law. According to the defendant, the claimants are relatives of the managing director, Captain Patrick Kekon, and contracted for service independently, which they were fully paid. The defendant stated that she engaged crews from time to time through the claimants who were and are still working for the for a different entity called KT Offshores Limited, a crewing company, but during the same office, sharing the same office with the defendant. According to the defendant, the first claimant in his purported resignation letter of 8th of February 2018 tendered his resignation as head of HR/admin of the defendant, which is inconsistent with his claim position in his sworn witness statement on oath and claim. The defendant never owed salaries of legitimate employees from inception until the defendant's business operation suffered a serious glitch because of a fire incident on the Niger Delta King, which incident occurred in Chevron's Agbani field on the 22nd day of September 2014. The said vessel is still under repairs outside Nigeria. The first incident put the defendant out of business as she could not earn enough income to sustain its operation. The fire incident extensively damaged the defendant's business beyond defendant's control and contemplation. It suffered significant financial losses after the fire incident. Thus, the, the event constitutes a force majeure because of which the defendant was forced to restructure and lay off most of the staff to cut down on the overhead. The incident paralyzed the defendant's business operation entirely and made it increasingly challenging to operate its company business and to pay salary as and when due. The defendant wrote to notify of its difficulty financial circumstances in a letter of 30th day of April 2015 and advised if any staff is unwilling to continue in his employment owing to the difficult financial circumstances, he may consider voluntarily leaving, as the defendant will not guarantee that wages or other payment will be paid regularly until the vessel was fully repaired and resume its normal operation again. The claimants have further exercised their right to voluntarily resign their appointment on the dates shown in their respective letters of resignation. They were neither dismissed nor were they appointed, nor they were neither dismissed nor their appointment wrongfully terminated by the defendant to warrant any damages or outstanding wages payment claimed by the claimant. On the letter of 4th of April 2018, putting on hold the claimant resignation, the defendant stated that the first claimant is an impostor holding out as director of the defendant, and the letter did not emanate from the defendant authorized officer to issue such a letter or letter of introduction to the bank. It did not emanate from the defendant. At worst, was initiated a written ultra bias under the power of the purported signatory and not authorized by the head of defendant. The defendant has never given an undertaking or reference for personal loan to any of its employees, directors, or independent contractors. Furthermore, the letter of undertaking to the bank was a forgery as its corporate name, as at the date quoted on the purported letter referred to, that is 15th day of June 2014, was not Incra Investment Limited, as the first claimant was indeed, if the first claimant was indeed an employee of the defendant and in the so-called position of executive director, he ought to have known as far back as 8th of March 2013 that the name of the defendant has become Incra Marine Limited, and the letterhead on which the reference was written was not that of the defendant in 2014. On professional fees of 5 million naira, the defendant above that the claimant are not men of no means and cannot pay the sum of 5 million naira as claimed when unable to service loan of 3 million naira. The defendants in the alternative lead that the action of the claimant is static bar and the claimant rights of action is barred on facts and law relating to leches and acquisits. The claimant's reply to the statement of defense. A reply, the claimants maintain that they were duly employed by the defendants as their letter of employment and job description were signed by authorized officers of the defendant. They are entitled to their claim. The first claimant admitted being distance relation of managing director, while the second defendant is managing director by consanguinity apart from being an employee of the defendant. The first claimant admitted being a nominal director of KT Offshore Limited, sharing office with the defendant, while the second defendant was neither a nor a director of KT Offshore Limited. The first claimant stated that due to the organization of the defendant in 2013, his status in the defendant was changed from executive director administration to head of human resource and admin, and placed on salary scale of 520,000 naira. The reorganization of the dependent was carried out between 2012 to 2013 after the dependent company procured and obtained a loan from Sky Bank PLC, now Prudent Bank PLC. Consequently, more directors and shareholders were introduced due to their roles in the loan procurement. Hence, the removal of the first claimant as director. The claimant stated that they were placed on allowances before 2012 when the organization and purchase of the vessels took place, and consequently, the reorganization and new salary structures, which was introduced with effect from 2014. The defendants maintained the old salaries from 2015, while other senior staff were paid, although one of the vessels, King of Niger Delta, suffered a fire incident on the 22nd day of September 2014. The defendant was and is still doing very well in terms of finances and operations since 2014 till date. As the second vessel has never suffered any incident and has been operational to date. The repairs of the vessel that was affected by fire incident is being carried out in South Africa, sponsored by the insurance fund that covered the incident. The fire incident has not put out the defendant out of business. The incident never constituted force majeure as the claimants were working on board and were not affected by any layoff by the defendant. The claimants were never served any letter of difficulty. The claimants willingly tendered their letters of resignation, as they were neither dismissed nor their appointment terminated by the defendant. The letters and acquiescence, the claimants stated that their course of action is not started by the course of action in respect of claimant of 2018, while for the second defendant in 2021, there was no delay in filing of this action in 2021, as the defendant were holding forth on assurances of managing director to clear all outstanding salaries. No notice of redundancy was brought to the notice of the claimant by the defendant. The submissions of the defendant, Eric Iperi Esquire, counsel for the defendant, adopted the defendant's final written address franked by him as his argument in this case. In the final written address adopted by counsel, 3 issues were formulated for the determination. They are whether on the facts pleaded and the evidence adduced by both parties, the claimants are entitled to any unpaid wages and damages as claimed. 2, assuming but not considering that the claimant is entitled to any unpaid wages to the claimant, is the claimant not stopped from making further claim against the defendant upon failure to file this claim within a reasonable time? 3, are the claimants entitled to any sum of unpaid wages and award of damages against the defendant's proper in the circumstances? Well, counsel, I don't know whether I should continue reading or I should keep reading the submissions so as to save time.
Yes, my lord. I think, my lord, if you go to the submission, to your decision. We can get the full judgment.
It's all right.
Judgment will.
Okay. In the body of the judgment too, I have captured the submissions of counsel for the claimant of Paul Ibiala, who on his part formulated 4 issues for determination. The argument on the 4 issues have been captured in the body of the judgment. So I now go straight to the decision of the court. The decision of the court goes like this. I have considered the processes filed in this suit by the parties, the evidence laid, as well as the written and oral submissions of counsel for the parties. The claimant's claim against the defendant primarily is for payment of arrears of salaries, payment of salaries and other entitlements to the first claimant, in line with the terms and conditions of his service from January 2022 until he is properly disengaged from the defendant's employment. General damages in the sum of 100 million naira in favor of the claimant jointly and severally for breach of terms of their contract of service with the defendant, and special damages in the sum of 5 million naira as cost of litigation. Let me say here before proceeding that the claimants file reply to the statement of defense. However, the said reply to the statement of defense did not have witness statement of oath of the claimants or any other witness that the claimant intended to call to testify in proof of the said reply to the statement of defense. In the circumstances, the reply to the statement of defense remains mere abatements and no more, as there was no evidence to prove the said abatement contained in the reply. In the circumstances, the law is clear that claimants have abandoned their reply to the statement of defense. The law is right that parties, as well as court, are bound by the reliefs put forward by the parties. The duty of the court is to determine the case in line with the evidence and law applicable to the parties before the court. Before the court made available by the parties. The defendant on his part denied the claim of the claimants and stated that there is no record in the custody of the defendant showing that the claimants held employment in its establishment on position and job specification claimed by them. There is also no valid contract employment placed before the court to enable the court to determine rights of the parties. The appointment letters tendered cannot qualify as valid letters of appointment. They are incomplete, disjointed, and not signed by the appropriate person responsible for approving employment as the defendant office. They are also not admissible in law. The claimants are relatives of the managing director, contracted independently, to which they were fully paid for the service rendered. The defendant stated it had never owed salaries of legitimate employees from inception until defendant business operations suffered a glitch. because of an fire incident that happened to one of the vessels neither Delta King. According to the defendant, the claimants have exercised their rights, voluntarily resigned their appointments on the dates shown in the letters of resignation tendered. They were neither dismissed nor were they wrongfully terminated by the defendant. Warrant damages to be granted or payment of wages. The letter of 4th of April did not emanate from the defendant's authorized officer to issue such letter. Likewise, the letter of introduction to bank did not emanate from the defendant. The letter of reference was a forgery, as at the date of the letter, 16th of March, 16th of June 2014, its name has changed from Inkara Investment to Inkara Marine Limited. The action of the claimants has been barred on facts and law relating to leases and acquisition. There was lapse of time and a reasonable delay by claimants in asserting their rights, as the claimants were silent for over 7 years. This amounts to defendants believing their claims are no longer interested in pursuing their alleged right. In their reply, claimant maintains they were duly appointed and that the first claimant admitted being the nominal director of KT Offshore and also shared office with the defendant. But due to reorganization, he was removed as director and now made human resource and admin and head of human resource and admin. That was in 2013 and placed on salary scale of 520,000 naira. The claimants were placed on allowances before 2012 when the reorganization and purchase of took place, and consequently reorganization in the dependent. The claimant have willingly tendered their resignation letters. Before delving into the consideration of the case of the claimants, I shall first and foremost consider the defense of statute bar, leases and acquiescence raised by the defendant in their defense and argued in their final written addresses. The defendant has argued that the claimant's claim is barred by the equitable doctrine of leases and acquiescence due to an unreasonable delay spanning for a period of more than 7 years before going to court to assert their right. The claimants in their response have argued that they are not guilty of any delay in instituting the suit before the court as claim their arrears of unpaid salaries and damages. They have also argued that the cause of action in respect of the first claimant arose in 2018 when the first claimant submitted his letter of resignation as against the erroneous misconception by the defendant that the cause of action arose in 2014. From 2018 to 2020, when this matter was initiated, is a period of 4 years, which is less than 6 years required as per Section 71E of the Liquidation Law, Cap 522 laws of the Federation. The contention of the defendant that the claimant's action is statute bar is incorrect. Counsel also submitted that all cases cited by the defendants are distinguishable as they are all on land matters, not on employment. There are different limitation laws limitation laws for land matters and recovery of debt. Even the submissions of counsel for the parties, from the submissions of counsel for the parties, the issue the issue on the claimant's suit being bad can be categorized into two. The first deal with statute of limitation, and the second deal with equitable defense of legacies and acquiescence. The law is settled that where a statute prescribed period within which an action must be commenced, legal proceeding cannot be validly instituted after the expiration of the period. And when an action is started back, a claimant who might otherwise have had a cause of action loses the right to enforce it by judicial processes because the period of time laid down by the limitation law for institution of such an action has elapsed. See the case of Aremo versus Adekanye. I quite agree with counsel for the claimant that in order to determine period of limitation, the originating process commencing the action is to be examined, i.e., pleading of the claimant, alleging the wrong when the wrong was committed, which gives the claimant a cause of action, will be considered. And by comparing that date with that on the which the originating process was filed, if the time on the originating process is beyond the period allowed by the limitation law, then action is statute barred. See the following cases: Omotayo versus Nigerian Railway Corporation, Egbe versus Ade Parasi, Shell Petroleum Development Company Limited versus Para, Aniboro versus Sea-Trax Limited, British Airways PLC versus Akin Yesoye, Woherem versus Emerua, Military Administrator Ekiti State, and others versus Alaye Lu, Allah Deyulu, and others. However, in the case at hand, the case was heard on the basis. This means the court will not restrict its consideration of issue of statute bar only by examining the originating process. In Karshi and others versus Gwagwa and others, it was explained succinctly that where an objection that the suit is statute bar is considered and determined after conclusion of evidence by both sides, then the court cannot ignore the evidence before it and pretend it does not exist and determine this objection only on the basis of originating process. At this stage, all the processes and evidence before the court must be considered, especially where the objection is determined as part of or along with the final judgment on the merit of the dispute in the case, as has happened in this case. This approach pursues the substantial justice of the matter and reduce the incidence or unscrupulous litigants who knowing very well that their claim is already started by coin a press their case or press their case in such a manner as to hide or misrepresent the fact that is statute bar, to exploit the principle that only originating process should be considered in determining the issue when the cause of action accrues and abuse the process of court, sending it trial of a stale course that lacks jurisdiction to try. End of quote. See also Mark Boko Useni and Alexander Manchika Atta and others. On the date of accrual of course of action, the position of the law is that a course of action accrues only when a right to make a challenge in respect of the subject matter against another person arises. See Induka versus Ogbonna. In computation of time, for the purpose of limitation, the court will not reckon with the date the affected party becomes aware. The court will only reckon with the date the course of action accrue. The view above is supported by the decision in Edogi versus Eboigi versus NNPC, where it was held, among others, this statute of limitation, as other statutes, begin to run from the moment a course of action accrues, not when it is discovered. It is therefore not an answer for a party as the, to rely on his absence from within jurisdiction or absence from court within jurisdiction to hear the matter. In determining the date on which the course of action arose for purposes of limitation law in the context of unpaid salaries, the course of action is in a claim for arrears of salary typically accrues when the salaries become due and payable, but unpaid. In the case of British Airways, Akinyosoye, the court addressed the period of limitation in a claim for breach of contract, which is relevant to claim for unpaid salaries. Applying to the principles enunciated in the British Airways to the present to the scenario in this case, the employee's salary was last paid for October 2014, according to the abatement contained in the statement of facts. Since the salary was due monthly, the next salary would have been due at the end of November 2014. Therefore, the course of action for the unpaid salary accrues from end of November 2014. Each subsequent month unpaid salary would have its own accrual date. This also means the resignation date would be of no moment, since the claim is not based on resignation, but on unpaid salary. There is no dispute that this action was instituted on the 18th of January 2022. This means from November 2014 to the date of filing in court of this suit. This suit was instituted after 7 years of accrual of the course of action. The relevant limitation period for contractual claim, including claim of unpaid salaries, is generally 6 years, as established in the case of Abubakar versus Michelin Motors Services Limited. Therefore, the claimants in this case would need to file their claim within 6 years from the date of the accrual of the course of action. In the case at hand, looking at the pleadings before the court, the abatements clearly shows that the claimants were employed in 2008 and 2009 respectively. They were paid monthly salaries through their account with Polaris Bank Limited up to October 2014. But the dependents suddenly stopped paying them their salaries from November 2014 till date. See paragraphs 4 and 5 of the statement of fact. It is clear as the daylight that the claimant's course of action in this case arose in November 2014 when the dependents stopped paying them their salaries, and not in 2018 or 2021 when the respective letters of resignation were submitted by the claimant to the defendant. This is because there is no challenge to resignation. The case of the claimant is built on non-payment of salaries and not on resignation. Therefore, the date of accrual of cause of action is from November 2014, which the claimant asserted claimants stopped paying them their salaries when the salary became due and was not paid. It is glaringly clear from November 2014 to 18th of June 2022, when this suit was instituted, is a period of about 7 years and 7 months from the date of accrual of the cause of action in this suit. Going by Section 7(1)(e) of the Limitation Law of the Federation, relied by the claimant, which provided 6 years for recovery of debt, this suit is caught by the statute of limitation. However, to me, the law relied by the claimant to submit that their case is not caught by limitation law is not applicable to this case. The relevant law applicable in this case is the limitation law of Cross River State, which by Section 15, it provides 6 years within which an action for recovery of debt or on contract can be instituted by an aggrieved party like the defendant, an aggrieved party like the claimant. The defendants have not, the claimants have not commenced the claimants having not commenced this action within the limitation from the accrual of the course of action. This suit is caught by Section 16 of the Limitation Law of Cross River State. The effect of the above finding is that the claimant cannot be allowed to maintain this suit as it is presently constituted. It is statute bar, same must be dismissed. The second leg of the defendant's objection to this suit is on laches and acquiescence. Claimants are of the view that the reasonable defense is not available to the defendant in this case, as according to counsel, there is a reasonable delay and the cases relied by the defendants are dealing with land matters. Let me say here that the doctrine of laches and acquiescence are indeed applicable to contracts of employment, depending on the specific circumstances of each case. Laches refers to an unreasonable delay in pursuing a right or claim in any way that prejudices the opposing party. Acquiescence, on the other hand, involve a situation where a party implicitly consent to a situation by remaining silent or inactive, thereby losing the right to assert claim later. The doctrine of laches and acquiescence is an equitable defense that operates to bar a person who has slept over his right for a long time from asserting his said right against an innocent party. It has its root in the equitable maxim that delay defeats equity and that equity aids the vigilant and not the indolent. It discourages stale demand in the interest of peace and orderly society, and it is thus rooted in public policy. See the case of Age versus Terrier. See also Olaleye versus Trustees of Equa. See also Atuchuku versus Adingu. A claimant who sleeps on his right, if any, for a number of years without claiming same or taking steps to protect such interest, cannot in later years make claim to same. See Daniel Kalio versus Daniel Kalio. See also Aure versus Iledu. Letters and acquisitions consist of substantial lapse of time, comply coupled with extreme circumstances which make it inequitable to enforce a claim. See Taylor versus Kingsway Stores Nigeria Limited. See also Oduto ICC. See also Agbara versus Amara. See also Adebo versus Onisola. Speaking on the meaning of latches, Ibu JSC of blessed memory in Kayode versus Odutola at page 683, quoted with approval the dictum from English case of Limise versus Petroleum Company versus FAD as follows. The doctrine of latches in courts of equity is not an arbitrary or technical doctrine where it would be precise, if practically unjust to give either because the party has by his conduct done that which might fairly be regarded as equivalent to a waiver of it, or whereby his conduct and neglect he has thought perhaps not waiving that remedy, yet put the other party in a situation in which it would not be responsible to place him if the remedy were afterward to be asserted. In either of these cases, lapse of time and delay are the most essential aspect of the defense. But in every case, if it is always the circumstances of the case that determine. Having regard to the facts that resulted in filing of this suit by the claimant, which I have alluded to, I have no doubt in my mind that the claimants are guilty of a reasonable delay in bringing this action. They have also shown that by their conduct that they have waived their rights to salaries. Otherwise, how could one be working for over 7 years without salaries and stood by and do nothing to assert their right? By remaining silent and inactive, the claimants have found themselves in a situation where they implicitly consented to the situation they found themselves in, thereby losing the right to assert their claim. They stood by and watched the defendant trample upon their right without doing anything to assert their right. Exhibit M, a letter dated 17th day of November 2021, is not capable of salvaging the inaction of the claimant in this case, as it was a letter written in anticipation of this action. The claimant's action, apart from being statute bar, is also caught by the equitable doctrine of letters and acquiescence. In the circumstances, this suit having been found to be statute bar, caught by doctrine of letters and acquiescence, is not properly before the court. In the circumstances, I hereby dismiss the claimant's action for being statute bar and court by letters and acquisition. Having dealt with the equitable and statutory defense, having dealt with the statutory and equitable defense, this court, being court of first instance, it is incumbent upon me to proceed to determine the merit of the case of the claimant's suit. This is because in case of an appeal, the Court of Appeal will have the benefit of having the views of the court on the claimant's action. I shall start by addressing the issue of admissibility of documents tendered by the claimant in the course of the trial. The counsel for the defendant has, in the course of the trial, indicated that he is objecting to the admissibility of document tendered in evidence by the claimant through DW1, i.e., exhibit DWA, DWB, and DWC. The court granted parties permission to canvass argument on the admissibility of the documents being objected to in their final written addresses. In line with the permission given to it, the counsel for the defendant canvassed argument on his objection to the admissibility of exhibit DWA, DWB, and DWC tendered in evidence through DW1 in the course of cross-examination. The grounds of the objection are that the documents were not pleaded, nor were they also front-loaded. Counsel further argued that there was no nexus between the defendant, DW1, and the document sought to be tendered. In support of this contention, counsel relied on the case of Alania versus Oyewale. In addition, counsel also objected to the admissibility of exhibit A, B, C, D, E, F, G, I, J, K, L, M, and N tendered in evidence by the claimant. According to counsel, these documents were said to be secondary evidence to which a foundation will need to be laid, as the whereabouts of the original was also not stated, while relying on section 83, 88, and 89 of the Evidence Act. Counsel asked the court to discountenance the value of the said documents in its determination. Since no foundation was laid in the witness deposition or orally in court, in support of this contention, counsel relied on the case of Ozenwo Onwuzurike versus Damien Edozian and others. In his response to the objection on admissibility, counsel for the claimants submitted that exhibit A, B, C, D, E, F, G, H, J, and N to 10 in number, tendered and admitted are all admissible without more in the state, and all form they were tendered. The first 10 documents are all original documents, while the other 7 exhibits are either copies of original or certified true copies of the original. It is submission of counsel that exhibit I, K, and M are documents which original copies are with the defendant, and notice to produce them was given to the defendant but failed to reproduce. Exhibit L is with Polaris Bank PLC. For exhibit DWA, DWB, DW, and DWC are public documents of which the law allows only certified copies to be tendered in evidence. In support of this argument, counsel place reliance on section 8E of the Evidence Act. I have thoroughly considered the objection of the defendant on the admissibility of the document tendered by a claimant. I have equally considered the response of counsel for the claimant on the objection. Let me start with exhibit DWA. This document emanated from Corporate Affairs Commission. It is a public document It is strike law for a public document to be admissible in law. It must be the original produced or certified true copy, in line with the provision of Section 109 of the Evidence Act. A careful examination of Exhibit DWA will clearly show that it is photocopy and not original or a certified true copy. In the circumstances, it is not admissible in law. Therefore, it was wrongly admitted in evidence, and this court has the power to expunge wrongly admitted evidence. In the circumstances, I hereby expunge Exhibit DWA from the record of the court for being inadmissible. See also on Woodbury versus Dodian. For Exhibit DWC, they are ruling and judgment of courts of law. Therefore, they are public documents. I have perused the said documents. It is clear to me that they were certified true copies. In the circumstances, they have fulfilled requirement of admissibility. The objection to the admissibility was based on misconception of law. The objection is hereby rejected. On Exhibit A, B, C, D, J, and N, these documents are all original. They do not need laying of any foundation. They are relevant to the issues in controversy between the parties. They have also been pleaded by the claimant having fulfilled the requirements of admissibility. They are not inadmissible, as the counsel for the defendant has argued in the circumstances. The objection of counsel for the defendant has no basis, as it is based on grave misconception of law. The objection is hereby also rejected. The next set of exhibits to consider the admissibility are Exhibit E and F. These documents were addressed to the first claimant. This means that they are documents in the custody of the first claimant. For photocopies to be admissible, the law requires the first claimant to lay foundation as to whereabout of the original and why the originals could not be produced. I have formed the entire pleading of the claimant and the first claimant witness statement on oath. I could not find where foundation was laid or required foundation laid as required by Section 8 of the Evidence Act. All that was stated is that the said job description and additional job description I hereby pleaded. It is right law that where there is proof that the original of a document has been lost, and all possible search for it has been made, the conditions precedent for the admission of the secondary evidence of that document under Section 90, subsection 1C, which would have been entitled and would have been satisfied, and the document may be admitted in evidence. See Ukachuku versus Uzodinma. See also Onochi versus Ikomi. In the case at hand, the claimants failed to satisfy the requirement for admissibility for Exhibit E and these documents being photocopies and foundation having not been laid have no probative value can be attached to them, but they are admissible in law. The objection on ground of admissibility is also hereby rejected. Exhibit L is a letter dated addressed to the manager, Skybank PLC. It was on letterhead of Incra Investment Limited, signed by Managing Director and the second claimant. In the case at hand, there is no dispute between the claimant and the defendant, as the letter was authored not by the it was not authored by the claimant. In the circumstances, it is not relevant to this case. It did not emanate from the defendant. In the circumstances, it is hereby discountenanced. Exhibit I and K are letters of resignation. The defendant have been put on notice to produce the letters but failed to do so. The secondary evidence is admissible and the admission of those documents was proper. I now turn to Exhibit G and H, which are bank statements of account of the claimant. Exhibit G seems to be electronically generated document as at the top of as at the top as at the top left hand corner. Date time it was generated was stated as 11th of 18th 2021 at 1:39 p.m. The website address of the document is contained at the bottom page of the document of the 10 documents. It is said to be report by one Messi Ojubo Orobi, staff number 09913, Calabar branch. The report covered period of 16th day of November 20. The document was not signed, even though the report was to be up to 18th day of November. At the end of the report, it ended on 31st day of May 2018. This means some 6 points report are missing from the document. For Exhibit H, it is statement of account of the second claimant. It covers period of 13th day of January 2013 to 19th day of November 2021. But at the end of the statement, it ended on 1st of November 2021. This means that there is deficit of some dates in this statement of account. Exhibit G and H being statement of accounts of the claimants with Polaris Bank are admissible in evidence if they fulfill the requirements of Section 89 and 90 of the Evidence Act. Section 89 provides secondary evidence may be given of the existence, condition, and content of the document when H, the document is an entry in banker's book, Section 90. The secondary evidence admissible in respect of original document refers to in several paragraphs of Section 89 is as follows. In paragraph H, the copies cannot be received in evidence unless it is first proved that 1. The book in which the entries copies were made was at the time of making one of the ordinary books of banks. 2. The entry was made in the usual and ordinary course of business. 3. The book is in control and custody of the bank, which proof may be given orally or by affidavit or by an officer of the bank. And 4. The copy has been examined with the original entry and is correct, which proof must be given by some persons who have examined the copy with the original and may be given orally or by affidavit. However, Section 90 creates an exception wherein it makes certain documents admissible under certain conditions, with particular reference to Section 89H and 91E. Copies of entries in bank books are admissible in evidence under certain conditions. The fulfillment of those conditions shall be by oral affidavit evidence showing that the exhibit are extract from a banker's book kept by the banker and that the figures copies out had been compared with the original and found to be correct. In considering the admissibility of entries in books or statement of account, Section 51, 84, 89, and 90 are relevant. Section 51 of the Evidence Act makes admissible entries in books of account or electronic record regularly kept in the course of business admissible whenever they refer to a matter into which the code has to inquire into. However, the same section provides that such statement alone shall not be sufficient evidence to charge any person with liability under Section 89H. Secondary evidence of the existence of conditions or content of an entry in banker's books is also admissible. The admissibility of each entry is, however, subject to fulfillment of the conditions stipulated under Section 90, subsection 1E. Section 84 allows for admissibility of statements contained in a document produced by computer. Banking nowadays have embraced the use of computers as noted. The exhibit under consideration seems to be electronically generated, which makes them admissible under Section 84 of the Evidence Act upon fulfillment of the conditions contained therein. It has also been held that in an attempt to satisfy the conditions stated in Section 90, subsection 4, it has been held that in an attempt to satisfy conditions stated in Section 90, before evidence of such is required to be verbatim, is not required to be verbatim reproduction of the facts in the section. It is sufficient that the provisions are substantially complied with. In Yesufu versus ACB, the Supreme Court, Fatai Williams, held that it is not the length of evidence given in tendering a bank account that matters, but the substance of the evidence given. nor is it compulsory that the precise words used by the section shall also be used by the witness. It is enough that substantially the requirement of the section are observed. See also the case of Kubo versus Dixon, Yesin versus Barclays Bank, and Ibwa versus Imano Nigeria Limited. Once there is substantial compliance with the provisions of 90 subsection 2E of the Evidence Act, banking documents are admissible in evidence. Furthermore, since G and H being statement of accounts are not inadmissible, they can once there is substantial compliance with the provisions of section 90 subsection 2E, banking documents are admissible in evidence. Furthermore, since H being statement of accounts are not inadmissible, they are admissible subject to certain conditions earlier explained. In the case at hand, there is no evidence that the claimants have fulfilled the conditions stipulated for admissibility of bank statement of accounts or entry made therein. In the circumstances, this court cannot accord Exhibit G and H any evidential value. It is pertinent to note that counsel for the defendant has also argued that Exhibit G and H are incomplete documents since they did not capture all the salaries of the claimants stated they had been paid by the defendant. The law is settled that once a document is pleaded, the whole document will become relevant. Since the whole of statement of account have not been tendered, Exhibit G and H cannot be accorded any evidential value. Having dealt with the admissibility of Exhibit I, or having dealt with the admissibility of Exhibit, I shall now consider the reliefs being sought by the claimant. I start with the relief 1 and 2, which are seeking for order of court directing defendant to compute, calculate, and pay claimants their outstanding salary arrears. For the first claimant is claiming the sum of 44,720,000. For the second claimant is claiming 21,375,000 naira. An employee claiming arrears of salary is required to establish a clear legal basis for the claim supported by cogent credible evidence. The first task to be performed by the claimant in order to prove their entitlement to salary is to establish their employment relationship with the defendant against whom the claim is being made. Therefore, the claimant in this case must demonstrate that there is contractual obligation for the defendant to pay them salary. This can be done by proving existence of contract of service, which specifies the salary of the employee. This is because the Labor Act, as per Exhibit 15, as per Section 15, mandates employer to pay wages as agreed in the contract of employment. The claimants are also required to provide by evidence that salary was not paid. This can be done by tendering pay slips, bank statement of account, or any other correspondence from the employer acknowledging the arrears of salary. In the case of NCS board and others versus Ijati, the Court of Appeal emphasized the importance of documentary evidence in proving salary. Also, in case of Selcom Tenare Limited versus Abubakar and others, the court The Court of Appeal discussed entitlement of employee to payment of salary and other entitlement. If on the facts proved before the court, they establish entitlement and non-payment. It is settled law that remedies available to an employee whose contract of employment has been breached are his salary and other legal entitlement due to him in the course of employment and nothing more. See Chukuma versus Shell Petroleum, Cooperative Bank PLC versus Asian, ATB versus Cable Metal Supra. As pointed out earlier, the burden of proof is on the employee to prove entitlement to arrears of salary. However, once a prima facie case is made out, established, the burden shifts to the dependent to satisfy non-payment of the said salary. In Balau versus Federal College of Education, Obudu and another, see Balau. What is clear from the decided authorities respecting payment of salary to employee is that both the claimant and the dependent has their respective responsibility in the proof or disproof. The obligation of the parties are well captured in the case of Ponica versus Sawmill versus Hope, where the court stated that as between an employer and employee, the onus is on the employee to prove that the employer employed him on a stipulated salary and that he worked for the employer during the relevant period. It is for the employer to prove not only that it paid employee his salary for work done by employee in the relevant period, but also how much the salary that he paid to the employee was. In the case at hand, the claimants have tendered exhibit A, B, C, D, E, F, G, H, and K in proof of their employment with the dependent. The dependent is also relying on alleged conflicting evidence. The claimant admitted at the hearing that they operated a company called KT Offshore Limited, a crewing company that shared office space with the dependent while claiming to be employee of the dependent at the same time. According to counsel for the dependent, this evidence makes it most likely for the court to conclude that the claimants were into full-time employment simultaneously. Counsel also submitted this raises substantial doubt in the minds of any reasonable person that the claimants were employed by the defendant under a contract of service and not a contract for service relationship. Counsel submitted there is no duty of employment between the dependent and the claimant, who at the material time operated and ran a full-time business with a company called KT Offshore Limited, which is their employer. This submission was not made based on correct evidence before the court. There is nowhere the claimant stated that or accepted that they operated a company called KT Offshore Limited. What is before the court is that under the first claimant under cross-examination stated that he served as nominal director of KT Offshore Limited, which share premises with the dependent. The company was doing crewing for other companies. The company does not offer any service to the dependent. The first claimant maintained that he was not offered services by the KT Offshore Limited. It is clear to me that counsel for the dependent is attempting in his address to give evidence which is not allowed in law. For counsel to rely on evidence, he must have pleaded the same evidence and adduce evidence in proof of the pleaded facts. It is also to be noted that second claimant was never asked any question on him being operating KT Offshore Limited or being its employee. The defendant maintains that no record in its record shows that plaintiffs held employment in its establishment for the position and those job specification claim, and no valid employment contract has been placed before the court to enable the court to determine the parties' rights. The claimants have failed to prove that they were employed as executive director and chief accountant in the defendant respectively. Neither have they adduced any evidence showing that they were used and performed such duties in the position they now claim, as the appointment letters cannot qualify as valid letters of appointment and are inadmissible for offending Section 89 of the Evidence Act. Besides being incomplete, disjointed, and not signed by the appropriate person responsible for approving employment of the defendant office. The defendant stated that the claimants are mere relatives of Managing Director of Captain Patrick Kepon, contracted them to serve independently. And they were fully paid for the services rendered. The defendant also submitted, contrary to the alleged status shown on the appointment letters, as executive director of the defendant, the first claimant in his purported resignation letter of H2 2018 tendered resignation as head HR admin of the defendant, thus inconsistent with the claimant claim position in the eyes of the witness. As pointed out earlier, in order to resolve issue of entitlement to arrears of salaries being claimed by claimants, the issue of claimants being employee of the defendants or not must thus be resolved. Let me say here that counsel for the defendant has in his submission made sweeping generalized submissions, assuming that the claim of the claimant is one and the same. The claimants are very clear that they were employed by the defendant at various times and on different positions. In the circumstances, the claim of each of the claimants on employment must be treated separately. The submission of counsel for the defendant clearly alluded that the claimants are not in contract of service with the defendant, but were in contract for service, for having been engaged by their relation, the managing director of the defendant, and they have been fully been paid. Under the Nigerian labor law, distinguishing between contract of service and contract for service is crucial, as it determines the rights and obligations of the parties involved, particularly in terms of employment benefit liability and statutory protection. The contract of service refers to an employment relationship where the employee agrees to work for an employer under certain terms. For this type of contract is characterized by master-servant relationships as control over the work performance of the employee, including how, when, where employee under the contract of service are entitled to various employment benefits which set out in the terms and conditions of service. See Sena Securities Limited versus Afropac and Shena Securities Limited and Afropac, and Omera versus NRC. Conversely, a contract for service is an agreement where an individual or a company contractor is engaged to perform specific tasks or project for a client. The contractor operates as an independent entity and is subject to the same level of control by the client employee. Independent contractors engaged in contract for service are responsible, is not entitled to employee benefits as an independent contractor, has the autonomy, decide how to execute the work, often use her own tools and methods. The distinction between these two types of contract has results of the court. See Shena Securities versus Afropac, where the Supreme Court has provided guidelines as to how to distinguish between these two employment. See also the case of Biokfo versus NDLA and others, where the court highlighted the importance of control and mutuality of obligation in determining the nature of the employment contract. In the case at hand, the claimants have tendered Exhibit ABCD in support of their claims of employment relationship. The defendant on its part did not tender any document in evidence in the course of the trial, apart from its oral account of apart from the oral account of their case, even though documents were concluded by the defendant, but they were never tendered in evidence. The reference made by the counsel for the defendant to those concluded documents which were never tendered in evidence must be discountenanced for the simple reason that Section 128 of the Evidence Act has made it clear that content of a document must be proved by document itself or secondary evidence where admissible. This implies for a document to be relied upon by the court, it must be properly tendered and admitted in evidence. The act of concluding documents, which involve filing them along with the pleading, does not automatically make them admissible unless they are formally tendered and admitted in evidence of the trial. See the case of University of Calabar and others versus Epion and others, where the court emphasized that it can only make use of exhibit properly tendered before it. Similarly, Obu and another versus Igwe and others, the court held that documents pleaded but not tendered at trial cannot be relied upon for determination of a matter. The courts have consistently held reliance on documents not tendered as exhibit would be contrary to the principles of fair hearing and the rules of evidence. In Ismail against the state, the court reiterated the reliance of documents not tendered in exhibit is impermissible. In the case at hand, the failure or refusal by the defendant to formally tender the front-loaded documents in evidence during trial is threatened to the utility of the document. They have no utilitarian value as the court will turn a blind eye to the document as they cannot be used for the purpose of making decisions. The case of the defendant to the effect that there is no record of claimant's employment with it has not been backed by any concrete evidence. The defendants need to go further to establish how the defendant conducted recruitment and the samples of their contract of employment with the employees. The mere denial and saying that the letters of employment tendered by the claimant are incomplete and disjointed cannot hold water. The defendant has a duty to prove his assertion with concrete evidence which it has failed to prove. It is also on record that managing director who signed Exhibit A, E, and F was in court the defendant in the course of the trial of this matter, and he was never called as a witness to testify to the falsity of or non-accuracy of the letters of employment, confirmation, and work description of the first claimant of the first claimant. DW1, who testified on behalf of the defendant, was not shown to be in charge of employment or staff matters in the defendant. He has also not established his source of information on the issue of employment that he testified not to have existed. Apart from calling witness, a party calling a witness is expected to call a witness that has personal knowledge of the facts on which he is to give evidence on. A witness that has not personally participated in the transaction on which he has given evidence will render the evidence not to be accorded any evidential value. See the case of Kate Enterprises Limited versus Daewoo Limited. See also Ayombosi versus RTV Briscoe Limited. See also Ishola versus Societe General Bank. In the case at hand, the evidence of DW1 will not be accorded much value, since the appropriate official who was even in court but was not called to testify. The defendant had also made heavy weather on the claimants being in full employment of KT Offshore Limited. This has not been supported by any concrete evidence, any concrete admissible evidence, though the first claimant has admitted being a director of the said KT Offshore Limited in the capacity of a nominal director. For the second defendant, there is no iota of evidence linking him with the KT Offshore Limited. Therefore, the claim of the defendant or suggestion to the court that claimants are employee of KT Offshore or were engaged by managing director independently to have been fully paid has no support from the evidence before the court. The defendant has woefully failed to establish that claimants are independent contractors, are not on contract of service. The defendant has also not adduced evidence showing that the claimants were engaged by managing director of the defendant as independent contractors and they were fully paid for services rendered to the defendant, as no evidence of such full payment was tendered before the court to convince the court that yes, the defendant has paid for the independent services rendered by the claimant. This assertion is a positive assertion in which the law requires the defendant who made the assertion to prove it, having failed to prove the assertion, the defense failed. Still, on the assertion that the claimants were in full employment of KT Offshore Limited, the defendant need to also show that the defendant has in its condition of service prohibited its employee from engaging on any business apart from maintaining their employment with the defendant. In the context of Nigerian law, the Companies and Allied Matters Act, which governs corporate affairs in Nigeria, does not explicitly prohibit a full-time employee being a director in any other company. However, contract of service being a binding agreement between the parties may have clauses that bar the employee from being a director in any company, whether nominal or otherwise. In the case at hand, the defendant has not shown by its conditions of service such a venture is not allowed. Since there is nothing before me to show that the defendant has restriction on his employee from being director in another company, the defendant has woefully failed to prove that first claimant being a director in another company is in full employment. It is also important to point out that article of association of defendant, which would have provided provided restrictions on directors, prohibiting them from holding any position in any other company is not properly before the court. Though front-loaded, it has not been tendered in evidence. I have looked at the article of association. Present state, it is incomplete. Page 13 is missing, which should have brought out the restriction, if any, on directors of the defendant from being a director in another company. Omission of page 13 may have been deliberate. Even though there is no any evidence of prohibition of employee of the defendant holding this directorship in another company, it will however amount to conflict of interest for an employee of the defendant to hold the directorship in another company, not particularly when there is evidence that the company is in which the first claimant is a director is engaged in business in which is engaged in a business in which is engaged in a business in which the defendant has interest in, i.e. crewing. In the case of Main Street Bank Registrars Limited by Susukandi, the court discussed the nature of directorship and potential conflict that can arise when an individual holds multiple directorships. In conclusion, while there is no outright prohibition under the Nigerian law for a full-time employee to be a director in another company, it is crucial and advisable for individuals to seek approval from their primary employer and ensure that the directorship is in another company does not conflict with their duties or create a conflict of interest. Failure to adhere to do so could lead to disciplinary action against such an employee. In any event, in determining existence of contract of service or contract for service, it is given fact that determine the nature of the contract and not what the parties call their relationship in any way they see it. In the case at hand, applying the principles of law enunciated in the case of Shena Securities versus Afropac to the facts of this case, it will be correct to state that the relationship that existed between the first claimant and the defendant from 2008 when he was engaged as executive director as per Exhibit A to 2013 is not that of contract of service. The reason being that by his own admission, prior to the organization of the defendant, the first claimant stated that he was being paid allowances by the defendant. In low payment of allowances to an engaged employee does not create contract of service between the claimant and the defendant. However, from 2014 to date of resignation, the claimant was supposed to have contract of service with the defendant. This is because as from the organization of the claimant, the claimant started earning salary, which has not been backed by any evidence before the court. For the second claimant, from 2009, when he was employed as per Exhibit B, he is in contract of service with the defendant. This is because his letter of engagement clearly stated his position and latest salary on which he was engaged. See Honica, Somi, and Shena Securities versus Afropac. Now, coming to the claim for arrears of salary, the claimants are claiming arrears of salary. The first claimant is claiming arrears of salary for 85 months from November 2014 to date of filing of this suit. There is evidence before me which is not disputed that the first claimant resigned from the employment of the defendant by the exhibit I, letter dated 8th day of February 2018. This means from 2018, the claimant was no longer an employee of the defendant. This was despite the fact that the defendant has put the first claimant's employment on hold as per Exhibit J. The law is tried once a letter of resignation has been tendered or submitted to the employer. The employee the resignation has become effective in law. It is not often to employer to reject a letter of resignation by an employee. Thus, the position of the law is that notice of resignation takes effect not from the date of the letter but from the date of purported acceptance, but from the date on which the letter was received by the employer. See Wayek versus Oshinebo. Once a letter of resignation is tendered by an employee, the employer has no option than to accept same, while there exists an inherent power in an employer or servant to resign from his employment. There appears, however, to be no discretion in any employer or master to accept same. The kernel of this principle is that resignation is not amenable or subject to rejection. See Benson versus Onipri. See also Adefemi versus Adegunde. The employer has no right to reject such a letter of resignation. To put the letter on hold will amount to violation of claimant's rights against forced labor. The Constitution of Nigeria, the Labor Act, as well as ILO conventions have made forced labor unacceptable in law. This means the first claimant in this case cannot claim arrears of salaries from November 2014 to date of filing this suit. This means the claimant can only claim arrears of salary from November 2014 to date of his resignation, i.e. 8th of 2018. The claimant can only claim arrears of salary for the period he was validly in service prior to tendering of his resignation. The letter putting on hold his resignation notwithstanding, as it is not recognized in law, as the defendant has no power to issue such a letter holding the resignation. Having regard to the foregoing analysis, the claimant is only entitled to claim arrears of salary for only 39 months, which are the months the defendant did not pay him from November 2014 to 8th of February 2018, when he resigned his appointment. In the case at hand, the claimant has not been able to establish his salary. This is because XBG tendered as proof of salary has been found not to have any evidential value due to non-compliance with provisions of Evidence Act. Furthermore, the defendant has challenged the claimant to prove all the salaries set to him by the defendant as claimed, since the defendant has denied the claimant being its employer. The first claimant has willfully failed to prove regularity of payment of salary from the defendant for the court to find in his favor. XBG, apart from non-compliance with evidence, did not reflect all the payment of salaries the claimant stated he had been received from the defendant. As pointed out earlier, the law is that reference to a document is reference to the whole document. Since the claimant has not tendered his statement of account showing the payment for the period he made reference to, the XBG, even if it was found to be properly before the court, is an incomplete document which has no evidential value. It cannot assist the case of the first claimant. In his pleading and evidence, the first claimant stated that he was last paid by the defendant in October 2014. Consequently, his claim is from November 2014 to date. However, a careful perusal of Exhibit G will show that the claimant was paid salary for January 2015 on 20th day of February 2015. Also on 6th of May 2015, claimant was paid salary for February 2015. I note also that there is no entry in Exhibit for payment of claimant's salary for July, August, October 2014. These inconsistencies in the claim of payment of salary by the claimant has rendered proof of his salary suspect. It is noted that claim for salary is a claim for special damages in which the law requires the claimant to specifically plead it, particularize, and strictly prove it by concrete admissible evidence. In the case at hand, the first claimant has woefully failed in his duty to strictly prove his claim for arrears of salary. In the circumstances, the claim for salary fails and same is hereby refused. For the second claimant, he has by the exhibit B and D established that he was employed by the defendant as chief accountant. The terms of conditions of service are attached to the letter of employment exhibit B. In the letter of employment, the claimant's salary was stated to be the sum of 90,000 per month. By the exhibit D, the second claimant employment was confirmed upon completion of 6 months probation. According to the second claimant, his salary progressed to the sum of 150,000 naira. Upon his employment, he was paid salaries through his account with Polaris Bank up to October 2014, but the defendant suddenly stopped paying salary from November 2014 till date. Second claimant tendered his resignation letter on the 4th of January 2021. An employee who has resigned his appointment is entitled to claim arrears of his unpaid salaries. The claimant by this action is claiming 75 months salaries and paid arrears of unpaid salaries in the sum of 21,375,000 naira. As pointed out earlier in a claim for salary, the claimant is duty bound to prove his employment with the defendant and the salary on which he was appointed. As found out, the claimant has proved his employment. The only area of dispute is on salary, because the claimant has asserted that his salary progressed up to 250. The defendant has tendered exhibit H to support his claim for salary, but the exhibit was found not to have evidential value. This means there is no documentary evidence to prove claimant's salary with the denial by the defendant of paying second claimant salary as alleged and challenging him to prove payment of the salary. It is to be noted that exhibit H did not capture all the salaries said to have been paid by the defendant. I have earlier on found exhibit H not to have any evidential value due to non-compliance with exhibit with Evidence Act. In addition, exhibit H is an incomplete document for not capturing all the salaries said to have been paid the claimant by the defendant. Furthermore, the claimant alleged he was paid last by October 2014, and his claim is for November 2014. I note there is no evidence claimant was ever paid October salary. There is also entries showing claimant was paid January and February salary 2015. These are discrepancies that the claimant has not been able to explain to the court. The second claimant has not been able to explain to the court. The law is settled that claim for salary is claim for special damages, which by law it is required to be specifically pleaded, particularized, and strictly proved. The claimant having failed to strictly prove his salary, he is entitled to claim for unpaid salary. Relief 3 is seeking for an order directing the defendant to pay first claimant his monthly salaries and all his entitlement in line with the terms and conditions of his service from January 2022 until he is properly disengaged from the employment service. This claim was based on a clear misconception of law. The reason being that as from 8th of February 2018, when the first claimant tendered his letter of resignation, he was no longer employee of the defendant. The defendant putting his resignation on hold, notwithstanding, the claimant having tendered his letter of resignation cannot claim any salary from January 2022 till he was properly terminated. as there was no any employment to be calculated, as he has exited his service when he tendered his letter of resignation as from 8th of February 2018 when he resigned. The defendant has therefore the first claimant is not entitled to any claim as per Relief 3. Relief 3 failed, same is hereby dismissed. The defendant has also stated that claimant has not rendered any service to it. For the claimant to be entitled to salary, he must prove that he had served the claimant for the period of claim, having not established that he has this relief, having not established that he has served for the period he is claiming, this relief cannot be granted. Relief 4 and 5 are ancillary claims dependent on grant of the main reliefs 1, 2, and 3. These reliefs having failed, the ancillary reliefs must also fail. The damages and the cost of litigation must also fail. From all I have been saying above, the claimants in this case have woefully failed to prove entitlement to any relief sought. This case having been earlier been found to be statute bar and quoted by the doctrine of leches and acquiescence is hereby dismissed. Before let me say here that this action is a classical example of the saying, procrastination is thief of time. The devastating effect of delay in taking decision to exercise the right which a party possesses is losing such right. The claimants in this suit have, by their refusal to timelessly bring an action, ended up in allowing their rightful claim to become stale. This is sad, as there is nothing the court could do to assist the claimant due to their own delay. The conduct of the claimants can best be described as equitable by the equitable maxim, which says delay defeats equity, or that the equity aids the vigilant and not the indolent. The claimant in this suit left over their right and acquires to dissipation of their right for a great length of time. If claimants have been vigilant and diligent, their story would have been different. In view of the foregoing finding, I hereby hold that the claimant suit was not instituted within the period allowed by law. The action is therefore statute bar, and it has also been caught by leches acquiescence. Same is hereby accordingly dismissed. I make no order as to cause party to bear their respective costs. Judgment is hereby entered accordingly.
The court pleases.
My lord, we want to seriously for the industry putting through the analysis I exhaustive and painstaking that you did a very elaborate of all the issues involved. And we learn more from we want to thank you very much, sir, for the effort.
Welcome.
My lord.
Welcome. Registrar.
That's my lord.
Call the next case.
My lord, that's all for today.
Okay, thank you. Thank you, counsel.
Thank
We have come to the end of today's proceeding. The admin, you can discontinue.